It is when we began now to move towards a single market that it became obvious we would have to visit with urgency the question of a tribunal. The meeting in Antigua of heads met in caucus. The Prime Minister then was the Most Honorable Edward Seaga. And I quote, "Caucus decided to avoid the option of a transitional involvement of Caribbean jurists in the Privy Council and take instead immediate steps towards the expeditious establishment of a Caribbean court as the final appellate body for English-speaking countries." End of quote. Ozzie Harding, King's Counsel, was a member of the Regional Attorneys General entrusted with the draft framework. Not one single ground has been advanced why this vestigial colonial institution should remain. What changed? The government. And the then leader of the opposition thought he was going to lure me with the fantasy of an indicative referendum. I was never going to succumb to that temptation. The differences between the two parties were reflected in our election manifestos of 2002. Now, the matter went to the Privy Council eventually, and let me say this. I accept the decision of the Privy Council because it is final, not because it is right. Why do I say this? What we lawyers call the ratio decidendi, meaning the reasons for the decision, are fundamentally flawed and indeed reflect a level of contempt which I find repugnant. Because on an examination, the Privy Council was satisfied of the quality of the composition of the court, its protection by a treaty, but it invoked what I call the doctrine of anticipated malevolence. What do I mean? What do they mean by that? Lest one prime minister would go rogue. And they said, one prime minister can interfere with the Caribbean court, but everybody knows nobody can interfere with us. Within 1 year of their saying so, Tony Blair changed the entire structure of the English judicial system and abolished the House of Lords as the final appellate court and instead constituted the English Supreme Court. I have to say that because I'm often misquoted by saying the law is not a shackle. I never said so. And I am sure the jurisprudence that is taught here allows people to understand that there are different approaches to the law. In my view, and I'm persistent in that, it has to be a tool of social engineering. Apart from my pleasure, which is customary, in seeing Mr. Bruce Golding here, he can attest to what I am about to say. The CCJ is our court. We fashioned it ourselves. We have paid our share for it. And having regard to the debate in Parliament, we made it an itinerant court so it can sit in Jamaica. It has now passed the 10-year test. One of our most brilliant jurists, Dr. Lloyd Barnett, wrote an assessment of the quality of the judgments issued, which I started to discuss with Mr. Siaga in an attempt to persuade him. But unfortunately, he fell ill before that discussion could be completed. During Mr. Golding's tenure, he commissioned quite understandably a study on whether we should have a final court, which is a Jamaican court, as distinct from the CCJ. And the answers are clear. We simply can't afford it. We're paying for one already. And we will be competing with the CCJ from the same pool of talent. Justice has a cost. And if we can find the money, we should use it to improve and perfect our justice system. That is why we all applaud the new remuneration package for the judiciary. I go further. We must retain the highest levels of competence. We can't afford judges of the Court of Appeal who are just getting in their ring hockey where the law is concerned, to be retiring at 70. We should be considering adjusting the age upwards to at least 72, possibly 75. Some cases have come to attention recently. There is a case of Lessine Edwards, where he was acquitted by the Privy Council. But you know why he was acquitted? The Privy Council made resources available for them to do a scientific study which was not available in the court here. And one thing we have to understand, poor people are denied the equality of justice because justice is costly. If Vibes Cartel didn't have the money, his case wouldn't have gone to the Privy Council. But his case should not have gone to the Privy Council if we had in place a system that records judgments